This conference will now be recorded.
Okay. All right, everybody, welcome. So I'm going to share my screen with you all, and I hope that you all will be able to see. And I'm going to pull up my whiteboard out. Can everybody see that?
Yes.
Okay, you should be looking at a white screen that says custody versus deprivation. So
Yes.
you'll have to forgive me. My handwriting, of course, when you're writing with your finger on your screen may not be the best, but essentially this is what we're going to cover today. We're going to cover it within the because somebody asked, I kind of realized when I did that, for those of you that were able to join in our appreciation event, I realized when I went, even though we did the trivia for fun and games, I did realize there was still a lot of information that you as members were lacking, or maybe just had forgotten, because, you know, you do your initial training and then we kind of get into case assignments and we may not have an opportunity to review that information a lot. So I am going to be resending out that initial training PowerPoint to everybody again. Of course, I am going to ask that in your spare time, 5 minutes you take to just glance through it. To kind of refresh yourself on some of the key points. But I'm hoping to do that today briefly as it relates specifically to custody versus deprivation, because I had a volunteer ask me the other day, she said, does one always mean the other? And that, at least that's the way she phrased it. I said, so do you mean that when there is a deprivation case, does the state always have custody? And she said, yes. And I said, no. And she kind of was surprised by that. She said, oh, I didn't think that there would be a deprivation case if the kids were not in custody. And I said, well, absolutely. I mean, I think that's probably a pretty general potential conclusion that a lot of people draw, but it is not accurate. So I want to talk about that broader issue because I think it's important to understand, but I'm going to talk about it within the flow of a deprived case, so that while we're talking about this, we're also doing a brief review of the general flow of a deprived case. Okay, so I hope that makes sense. If you have questions, because I've got so much going on my screen, let me see if I can pull up the chat function. Yeah, it may be a little hard for me to, if I'm not responding to your chats fast enough, just let me know. Okay, so here we go. In the context of a deprived case, let me start by reminding you that when a deprived petition is filed, it does not necessarily mean that the state has assumed custody of those children. And when I say that, people are kind of shocked. So there's always going to be an investigation that initiates a deprived case. Okay, there is a referral made to the Department of Human Services hotline, and DHS reviews that referral and they assign it a priority. So you've got a referral is your first step. Okay. Once DHS, now if DHS eliminates obviously any concerns during the course of that initial investigation, then they might help the family with additional services, but it doesn't necessarily mean that they're going to turn that to the DA for potential consideration. But for purposes of today, we are always going to assume DHS receives a referral, they assign it a priority, and they complete their investigation, okay? Now, let's say in this example that they do their referral and the only allegations in the case are marijuana. The mom's using marijuana. Other than that, mom's got a good job, the home is safe and appropriate, the kids are in school, there's no other signs of abuse or neglect. Now, depending on your own personal positions, I know everybody may have a different answer to this, but would you all, or could you agree that marijuana, knowing or me reminding you that the burden to remove custody of a child from a parent is immediate threat of harm? If that's your threshold, would you all agree that marijuana may not fall within an immediate threat of harm to a child? Can you see that, or potentially force? Now, some people I know feel very, very strongly about drug use, and they feel like, so, but I'm asking just for kind of a moderate viewpoint. if, the children are in school, kids are happy, mom's got a stable job, but mom just happens to smoke marijuana sometimes at night to ease her anxiety, sometimes over the weekend with friends. Would you agree that there is that it would be hard to find that there's an immediate threat of harm to the kids?
Yeah, because it could be medical marijuana.
Yes. Let's say for this example, it's not, though. Let's say
Okay.
she doesn't have her card. So I can't see your faces. So you're going to have to be more, if you don't show your faces, you're going to have to be more verbal with me on your yes and no's, because I can't tell. But okay. So in that instance, though, it's illegal, right? And let's say mom's levels of marijuana are high enough that they're indicating she uses daily. Okay. So let me ask you a question. Do you think it's possible to provide services to that family while the children remain in mom's care and custody?
Yes.
Yeah, right? Absolutely, right? That's kind of common sense, right? So in that instance, DHS can recommend to the state that they file a petition, but, and this is really interesting on the handwriting, custody remains with the natural mom. Okay? So, follow me. In this very brief example, that is, I think, probably one of your more classic examples of when the DHS gets a referral, completes an investigation, says, hey, look, mom's using a lot, man, and so there is potential for danger there. She is open to services, but we certainly think it would be much more traumatic to take the children out of the home than to let them stay in while we work with mom. So DHS immediately makes a referral for substance abuse treatment. They put mom on the UA system, just like they would if the children were in custody, right? There's no differences in the services that a parent can receive. Custody does not affect that. So again, another boundary, and you will hear me say this 100 times, this is custody and deprivation in these cases. They are not mutually exclusive, okay? So in this example, the state can file a deprived petition. Let's say they do. Mom says, yep, I admit it, I'm using, and the children remain with her. She works her services, she gets treatment, and by 3 months, she's testing negative. Right? So at that point, the DA would probably recommend, and even if they didn't recommend, the state would probably, the courts might consider just closing the deprived case at that point, okay? So that's your simplest example, I think, of how a case always initiates with an investigation, but it doesn't always mean a removal of a child, okay? So in this instance, if there was an investigation, and I'm sticking with my hypothetical right now that I just gave you about mom and the marijuana use, right? So we had the, oh, gotta go back to my pen. We had the referral. We had the investigation. We had the petition. We had the treatment plan or dispo. Now I just did bad there. Because I'm going to tell you guys to never refer to it as a treatment plan hearing, because that's not true. Although 72. So disposition hearing would have been when, oh, and I missed it. Hang on just a second. Petition. Adjudication. Dispo and review / permanency hearing. So essentially in the example I just walked you through, we started with a referral. DHS completed the investigation. They did not remove the children. Well, DHS, first of all, let me reiterate. DHS gets pegged and a really bad rap a lot of times for being the one to make a lot of these decisions. They always say DHS removed my children, DHS terminated my rights. That in itself is not 100%, it's not accurate. It's really not accurate at all. DHS, if you recall in our initial training, we talked about the parties to a case. And I told you that it shocks everybody when I tell them DHS is not a party to these proceedings. The state of Oklahoma is. So while DHS may get the referral and they may do the investigation, who files the petition?
I thought it was DHS.
Nope. I know. It's crazy, right? The district attorney's office files the petition. So the internal process is that once DHS completes their investigation, if they think there should be a petition, they go and staff it with the DA's office, and only the DA's office under the law has the authority to file a petition. They can look at DHS and say, nope, I don't agree with you. I don't really care that mom smokes marijuana. Whatever. We got enough, to worry about. We don't need to be adding that. Make a referral for mom. She can get services on her own. And if she doesn't, then she risks another referral and another investigation. And obviously, if we've given her one opportunity to get treatment and she doesn't, it's going to up the ante if she gets another referral. So DHS merely makes a recommendation. It's the state of Oklahoma, specifically the district attorney's office, that makes the legal determination if there is sufficient evidence to file a deprived petition, and then they file it. Okay, DHS has I can't tell you how many times as a DA, DHS came to me with a request to remove, either remove kids, or B, to file a petition, and I said no. Because after I evaluated the case, I didn't feel that there was sufficient evidence, or I felt like there could have been preventative services offered first. So again, DHS is not a party to these cases. They don't prosecute anything. They don't do anything. They make, they do everything, which is kind of funny, but they make recommendations to the parties in the case who then have the legal responsibility or the legal authority to proceed with to be the moving party in the case. So let's say we're further along in the case, DHS can recommend that the case be dismissed. But if the state doesn't agree with that, they don't have to request that. DHS can recommend termination of parental rights. But if the DA's office yet again feels that there's not sufficient evidence, or when we get to termination, the child's attorney also has the option of filing a termination petition, but they have to do that based upon their ability to meet their evidentiary burden as well. So to clarify and to remind you, DHS is not a party to the case. So in the marijuana example I gave you, the flow of the case, and this flow right here that I'm showing you, we're going to go into it in a little bit more detail with the other examples I use, but this is your very general flow. You've got your referral, your investigation. Now, in this area here, quite frankly, and more often than not, you will have a custody determination, and that will be the next examples that I give you. But right now, you've got referral, investigation, petition, adjudication. That's the hearing where it's determined if the child is deprived. And if you recall, we talked that there are several ways to do that. A parent can agree to the allegations. They can say to the judge, I'm not going to agree to this, but I'm not going to contest the state's evidence. I'm going to let them tell you their evidence. And if you find that they've met their burden, then that's what you find. I know most of you have heard of a no-low plea or a no contest plea in a criminal proceeding. That is the equivalent of what I just described in a deprived proceeding, but we call it a non-jury trial stipulation. So the first, when the parents agree, is a stipulation. Then they have the option of a non-jury trial stipulation, which is I'm not going to contest the evidence, which is like the no-low plea. They can have a non-jury trial before a judge. At this phase of adjudication, they are not entitled to a jury trial. Or because, and here's a real kicker, these are, please recall, I'm going to write it up here in words that are big. These are civil proceedings. These are not criminal proceedings, okay? Deprived cases are classified as civil proceedings. So because of that, there are, for instance, I think one of the biggest impacts that we have in deprived cases because it's a civil case is that if we are able to affect service, appropriate service and a parent fails to appear, in a civil case, once you've been notified of something and you don't show up, that is your consent to the request that's before the court. So if a parent is served with a deprived petition and they don't show up to their court date, the law says, hey, you were given notice and opportunity. Your failure to appear is basically you consenting or defaulting on the judgment in the petition. So if the state asks in their petition that the children be found deprived and you're served and you don't show up, the court's going to find your children deprived. Okay, so those are the four. Yeah, any questions so far?
Nope.
Okay, so yeah,
One quick question. If they don't show up, so does that automatically mean that they're the non-jury trial stipulation? Or
yeah, that is a very, very, very good question. No, it just means that literally the judge can, on their failure to appear alone, find that the children are deprived.
okay, so that's the verdict or whatever. That would be what.
That's
okay.
the judge's decision. And then you've got, after the adjudication hearing, the next hearing is the disposition hearing. Number 5, this is the single-handed most important hearing that occurs in a deprived case. It should be. There is a lot that statutorily occurs at disposition. The court will decide placement. The court will decide a treatment plan for all parties. They will decide visitation plans between siblings, between parents, between relatives if necessary, and they will make a determination about the permanency goal in that case. And remember, the permanency goal is the goal that the court is telling DHS, this is the goal you have to make reasonable efforts toward. So at this disposition hearing, in my marijuana example we started with, what do you think the permanency goal of the court would be? What would they tell DHS to make efforts toward? Emily Meyer, you are on here, and I know you know the answer to this. Where are you?
Yes, ma'am.
Poor Emily, she's heard this a million times. So in the example I gave you, return home is going to be, there's only 4, there you are. Deb, yeah, you too, you know the answer to this. There's 4 recognized permanency plans: return home, adoption, guardianship, and planned alternative placement. So those are the 4 that exist under federal law. Now, you can have what's called a concurrent plan, which is where you always under a concurrent plan.
Those.
What'd you say, Marilyn?
Would you repeat those? I got return home, adoption. What were the other 2?
Guardianship.
What?
And alternative placement.
Okay.
Now, if you're interested, I did a training back in December on the 2 different types of guardianships. If you're interested, that they didn't tell me they were going to do this, so I about murdered Keith Pirtle, but they put the stupid thing on YouTube. So you can actually go and find that training on YouTube. I about died. If you ever are curious about the 2 guardianship options in Oklahoma, but because we won't talk about those today. But those are the 4 plans. Now, a lot of times courts will do what I call hedge their bet. So if they have a case where they're like, yeah, we're obviously going to give parents a treatment plan and give them the opportunity to correct the conditions, but look, it's not looking good. We've been here before, they've got I'm just using this as examples. They've got a major addiction issue. They might say, okay, our primary goal is to return home, but our concurrent goal, and that's a whiff sign, is adoption. So DHS now has to make 2-prong efforts, right? They've got to make reasonable efforts toward the goal of returning home and reasonable efforts toward the goal of adoption. And those efforts are evaluated by the court at the permanency hearing, which has to be held every 6 months under law. Now, I will tell you, I have this review and the permanency hearing written down here as the same. I want to make clear they are 2 separate hearings and they do 2 separate things. But in Tulsa County, 90% of the time they're combined into one hearing, okay? And it will say review/permanency hearing. But just to very briefly cover the differences, a review hearing is where the court is reviewing the status of the case. So how is parents doing on treatment plan? How are the kids doing on their treatment plan? How's visitation going, etc. Okay. The permanency hearing is what? Can anybody take a guess? What's the permanency hearing?
For adoption?
It's to determine the permanency plan. Yes, exactly, Marilyn. So at a permanency hearing, the judge is looking at the last goal and looking at the efforts DHS made to meet that goal. And then they're asking, should this still be the goal or do we need to change it? Okay. So in my marijuana example I started with, obviously at disposition, mom would have gotten a treatment plan. The kids would have gotten a treatment plan. There wouldn't have been any visitation schedules because they're all residing in the same home and mom retains custody. The goal would have been return home. And at the next review hearing, under the idea that mom got treatment, is testing negative, at that point, it would have been a review/permanency hearing. And I anticipate that state would have recommended that the case be closed after successful completion, okay? So that's the flow of your deprived cases. Now, I will tell you that in my next few examples we're going to walk through, obviously this review permanency hearing, this last set of hearings, those hearings continue until the case is closed. So you may have 19 review hearings and 19 permanency hearings during the life of a case. It just depends on how long that case is open. So now let's get to the definitely the example that you see more often, okay? And here's the example that you see more often. So what you all tend to see is you have the referral. Oh, gotta go back to my pen. You've got the referral. You've got the investigation. Now, we're going to stop here and I'm going to give you a new example. So, in this example, DHS gets a phone call or a referral to the hotline and says, we see numerous people coming in and out of mom and dad's house all hours of the night. They don't stay for long. It could be up to 20 people a day. The children aren't attending school regularly. They're locked out of the house all hours of the day. They are neglected. Their clothing's dirty. They're, emaciated. They look like they haven't bathed in several weeks. We hear yelling. We hear screaming. We hear things shattering. And so they go and investigate and they determine that, mom and dad have a meth lab in the house. And so they're cooking and selling meth. That the children have been exposed to the toxicity of those fumes. They had, rotted food in the sink and in the refrigerator. Children reported maybe getting one food item every few days. They had not bathed. So, their hair was crusted, had lice. I mean, we could go on and on and on and on and on. There's domestic violence in the home. And so would you agree under my example that I gave you that those children are an imminent threat of harm? Yeah. Yes. Yes. Beth, I see you. Yes. Yeah. I mean, sorry, if you didn't agree with that, let's chat. I'm just joking. That's a joke. But yeah, I would say this is more the level of kind of imminent threat of harm, right? Where really, truthfully, there could be starvation, there could be injury, there could be toxicity exposure. So DHS completes their investigation and they say these children cannot remain in the home. So they go to the district attorney's office and they give district attorney all the information. The district attorney says, absolutely, I agree with you. They work together. Well, Emily's going to laugh at this. I used to work together with my DHS workers to write the affidavits, but times have changed and now really DHS does us almost entirely on their own. and you take the affidavit to the judge and you have the judge review it, and it's an ex parte, so it's an emergency order, right? Meaning nobody's been given notice of this yet, and the judge reviews it and says, yes, I think there is sufficient evidence to establish these children are in imminent threat of harm, signs the order to remove the children. Okay? Now, that is your most common method of removal. I'm going to tweak my example very slightly just to demonstrate the other. So at the same time that DHS gets the referral, the police are called to the home. The police go out and find the active meth lab, which I don't know if you know this, but meth labs have a tendency to blow up. They're not very stable. They're certainly not safe. So the police can, under the law, do what's called protective custody, meaning without a court order, the police have the authority under the law to remove the children into protective custody, meaning they can put them in the car and they can take them to DHS if DHS did not arrive on the scene at the same time. But they'd have to immediately, DHS has to immediately set that with the case DA to get a court order, right? So protective custody is that, oh man, we're gonna, we got everybody in the house, mom and dad are high, they're freaking out, we're gonna get the kids out of here. That's protective custody. Protective custody is always followed by a court order, which then makes that emergency custody. Now, I'm not going to go into the legal mechanics of those, but just know that those are two different kinds and that they do exist. So DHS goes to the DA, like I said, the court order says, we're going to remove these children. So after the removal, the next hearing, this has several different names. In Tulsa, it's most often called the show cause hearing. In some counties, it's the 48-hour hearing. In some counties, it's the emergency temporary hearing. They're all the same thing, okay? Essentially, this hearing, which in Tulsa County is called show cause, that is where, so DHS might have gotten, let's say DHS got the investigation, because of in that meth lab fact I gave you, they made that a priority one. So they went out to the home within, what is a priority one now? Emily, is it still 24 hours?
Yes, 24 hours.
Okay, so they had to go to the home.
It's not 24 hours, it's same day before midnight. So it could be 24 hours, but it could be 2 hours if you get it at 10 p.m.
Okay, got it.
Same day before midnight.
Okay, so obviously it's a very immediate need. So they go out within this, period of time, they do the removal. Well, between that removal and this 48-hour hearing, because 48 hours does not include weekends, it's business, right? So if the removal happens on a Saturday, the 48 hours is going to be usually on that, Tuesday, Wednesday? My math is really bad, which is why I went to law school. But that being said, they will continue their investigation between the removal and this hearing, okay? And they'll be looking at placements for these kids and potential foster homes. So we come to the 48-hour hearing, and this is the first opportunity for the parents to, talk to the court. And in all honesty, guys, there is a lot of things that can happen here, and we're not going to be able to cover all of that. But I think what typically happens is that at this point, the kids are in a foster home. For purposes of my example, we're going to say grandma. They were immediately able to get in touch with grandma. They ran some initial checks. They did an initial home visit. She appeared to be safe and appropriate, so they put the kids with grandma. But let's say the kids get to grandma's and they're like, we don't want to be with grandma. We don't like her. She's mean. She yuck, and they don't want to be there. They want to be with aunt. So in the meantime, DHS can be exploring these other potential placements, right? Until they kind of determine what the best placement for the kiddo is. But let's say they get to the show cause hearing there. I do want to note, there are lots of examples and cases where at this show cause hearing, the judge might release the children from custody. So remember my marijuana example we started with? Well,
Yes.
let's say DHS went out to investigate. Mom was asleep and passed out and the kids were unattended. That might lend more to the immediate threat of harm, right? Because if mom's smoking so much that she's passing out and not keeping eyes on her 2-year-old, that's bad, right? So in that
Right.
situation, DHS might have immediately decided to remove the children. But then let's say they get to show cause and mom is like, here's my UA, I've already signed up for treatment. I am, you can hear DHS has talked to neighbors who say she's a very good mom. The kids aren't neglected. They're going to school. Can, at this show cause hearing, the judge decide to relieve them from emergency custody and return them back to mom?
Yep.
Yes, absolutely. Remember, custody is fluid. It's fluid. Custody can change at any minute in a deprived case. Any minute. We are not bound by anything we're bound by, okay, that was a bad way to say it. It is a very fluid thing. Custody can change throughout the life of the case. So they could have been removed, and then at this show cause in my marijuana example, the judge could have said, okay, I agree with you. I don't think there's any immediate threat of harm. You've gotten into treatment. You've already started. DHS is reporting you have a good support system. So I'm going to return the children to your care and custody. Now, if he does that, can the state still file a petition?
If he
No.
releases,
If he releases the children from custody, can the state still file a petition?
yes.
Yes, right? Because the track for deprivation and the track for custody are two different things. Remember, they're not woven together. And I think a lot of people presume that they are. So I gave you the first example to demonstrate that you can have a deprivation case in which the children are never in custody of the state. They are always in the custody of the parents. Okay? You can have a deprivation petition or a deprivation case where they're in custody with mom and dad at one moment, back in custody with the state next, back with mom and dad the next. Or you can have a deprivation case where they are removed at the beginning and they never go home to mom and dad. So again, custody is fluid and they are not, they're mutually exclusive. So in this example, if the judge chooses to release them from emergency custody, the state can absolutely still file a petition because mom's still using marijuana, right? She's
Right.
still using. It's just that one element, custody, looks at the threat of the harm of the children remaining in the home, where the deprivation petition looks at whether or not there is abuse or neglect that requires treatment and or potentially termination if it's severe enough. Do you see how there are two different standards? And two different
Yes.
ideas? Okay, so that was how I wanted to demonstrate that. Now, if we go on, regardless of custody, the next obvious thing, regardless of who has custody, is the petition, then it's the adjudication, it's the disposition, it's the review and permanency hearing. So you see that these core points in a deprived case do not change. The flow of a deprived case is always the same, okay? It's going to be referral, investigation, potentially removal. If removed, there's a 48-hour hearing. If they're not removed, it goes straight to the petition, adjudication, disposition, review, and permanency hearing. So the flow of these cases remain the same. Custody may weave in and out of them. So to make that a little bit more clear, let's go back to my meth example. So we get to removal. You all would agree they needed to be removed in my meth example, right? We get to the show cause. Now we're going to reverse course, or in my meth example, sorry, not reverse course. The judge, in addition, now DHS has discovered that in addition to domestic violence and substance abuse and neglect, that mom has a diagnosis of bipolar, okay? And so now we've added mental health it concerns into the mix, right? So by the time we get to the show cause, the judge is like, yep, this is not good. These kids are definitely at imminent risk of harm if they remain in the home. So again, in this example, the children remain remain in emergency custody. So they, in the example we're discussing now, or not example, but yeah, just hypothetical, they stay in custody. What's the next hearing going to be?
They do a filing announcement and adjudication.
Yes. So filing announcements, that's the same thing. I was calling it a petition.
Yeah.
But in all honesty, you will not find a filing announcement in the statutes. So it's not technically a hearing. So don't worry about that. But you're right. After, we'll call it petition, because if the judge orders that they stay in custody, the state they will stay in custody, and then the state files their petition. What's the next hearing after the petition is filed?
Adjudication.
Yep, adjudication. Now, let's say we get to adjudication, and mom and dad, you know, they are still very active into their drug use. So they are not going to admit they're addicts. They're not going to admit they're anything. They're very paranoid. They're having a lot of problems. They say, Judge, we want a trial. We want a non-jury trial. So the judge sets the non-jury trial out, but because of the docket concerns, it's set out for 2 months. Right? So now this is 2 months where these children stay in emergency custody. Okay? Because at this point, until adjudication occurs, children are in emergency custody. Okay? So this is emergency custody. These here. Now, once adjudication occurs, the custody status slightly shifts. But again, we're not going to, it's still custody. That's all y'all need to know for today. But adjudication, so they set this out 2 months, right? Well, guess what happens in those 2 months? Mom realizes, oh, dang, I got a problem. I was using the meth to self-medicate. Dad was forcing me to help cook. He was injecting me when I was sleeping at night. So she starts having these conversations with DHS. They're making referrals for her and the family this whole time to work surfaces. It's not like DHS just stops. So while we're pending trial, DHS has made referrals. Mom and dad, dad is like, just no, he's not having it. He's still actively using. He is, in and out. But mom, with DHS's help, separates from dad. In these 2 months, she gets into treatment. She does her first 60 days of treatment. Well, she does, let's just say for my example, 30 days of inpatient, and she gets out and transitions into like a sober living facility for the next 30 days where she remains. She gets a job. She's holding her job down. She's visiting consistently, and she's back on her medications for her bipolar disorder. So now we get to adjudication at the non-jury trial. Okay. The parents say, mom comes in, dad is like, I still want my trial. Mom comes in and says, you know what, Judge, I don't want my trial anymore. I recognize that I have these problems, and I'm going to stipulate to the petition. I'm going to agree that all of those conditions existed. Okay. So when she stipulates, now the children are deprived. Okay. When she stipulates, that is when the court makes the finding that the children are deprived, right? Because she's told the judge, I did all this. I mean, I agree. So the judge says, okay, I find these children deprived. And mom says, but judge, here's what I've done. I'm testing clean. I've got a job. I'm in a sober living apartment where I have support. I want the children placed back with me. I want them to be returned to my custody. Okay. Can the judge return the children to mom's custody?
Yes.
Yes, he can. Because remember, custody is fluid. Custody can change. So if the judge agrees, and maybe the state ejects, maybe they don't, we won't get too detailed into a hypothetical, but let's say the judge says, okay, you know what? I agree. I'm going to return them to your custody, And I'm going to set the disposition hearing out the same day now as dad's non-jury trial, 30 days from now. Okay, so then we get to the disposition hearing. Mom gets her treatment plan. She's still doing really well. The kids are in her care. Dad's still not doing anything. He does not show up for his non-jury trial. What happens when he does not show up?
His rights can be terminated by consent.
Well, only if the
Or
petition
it's
asks.
adjudicated by consent at that point.
Yeah, so if the petition asks for adjudication only, which for purposes of my example, it does, he could be that the children can, again, they're not found deprived again. They were already found deprived once. Instead, the court makes a finding when he failed to appear that he's agreeing that all the things the state said he did wrong, he did wrong. And all those conditions he needs to correct are the ones he needs to correct because he failed to appear. And remember how we talked about that was one of the 4 ways that adjudication can occur by consent or default. Okay. So we're going to kind of take dad out of the equation because he's not participating and nobody can talk to him. So we get to disposition. Mom gets her treatment plan. The kids get their treatment plan. Obviously, there's no visitation schedule because they're with mom. And the judge says, okay, the goal, obviously, because the kids are with mom, is return home. Okay. So we go out to the next hearing, which is what? Who can tell me what the next hearing is? And not Emily this time, because she knows. Remember what it was after dispo?
Removal?
It's a
Review.
permanency planning review of the case.
Yeah, it can be the review and or the permanency hearing. They can be separate or they can be together.
Okay.
Okay. Remember, so for this example, I'm going to alter it a little bit and say that after this dispositional hearing, the judge set out the review only, a review only, for 90 days after disposition. Okay. So mom leaves court, she's got her kids, she's got her treatment plan, she goes and works her services, and 90 days later, we're set for a review hearing. And at that review hearing, we're looking at mom's progress, right? I mean, we're looking at how well she's done on her treatment plan, how the kids are doing. Well, let's say that we're coming up to the review hearing and DHS writes a report and DHS discloses in the report that the day prior to the hearing, they went to do an unannounced visit. Mom was in the house. She was passed out. There was a needle on the table and dad was in the home. What do you think is going to happen at this review hearing?
Take the kids back into custody.
Yeah, so exactly. And more than likely, under that example, DHS, so they go the day before this review hearing. Yeah, Beth, take the kids away. Exactly. The day before this review hearing, DHS does an unannounced visit to mom's home, and like I said, finds mom in this state, in this condition. So they go to court the next day. Well, they don't even leave mom's house. Let's use this, what would more accurately happen. They're going to call the DA while they're at the house, and they're going to be like, this is what I found. We need to remove these children from mom's custody and put them back in state's custody. Now, does DHS have to go get an order from the court?
No.
No.
Well, in my example, yes. In the example I gave you, because remember up here, we talked about the fact that, or no, wait, do we? Yeah, sorry, I need to take this off because I changed this once we talked about it. Here they stayed in custody, but remember at disposition, they gave custody back to mom?
Okay.
Right, so you guys don't have to memorize this. I want you to just listen. Like I'm asking questions just to kind of make sure you're engaged, but this is not memorizing. Once you're going to start to see this same picture, it's going to have different facts, guys, but you're going to start seeing the same picture over and over and over. I'm just using examples to highlight how these things are mutually exclusive. So at disposition, remember, the court gave custody back to mom. Gave legal and physical custody back to mom. So when they got to the house and found dad in the home, they have to get a new order for custody from the court, right? Because we're making a big change. DHS is not a party, right? They don't, under the law, have the authority to remove the kids unless they had, which we'll talk about in our next example. So in this particular one where the judge gave legal and physical custody back to mom at dispo, but then mom backtracks, they have to go and get an order removing the children from the judge. Does that affect the deprived status of the case?
No.
No, right?
Well, here's a question. If after the disposition, the judge gives the children back to the mom, is the case then closed? And is that why they have to start over again if they go back?
They don't start over again. Nope. So in the example I gave you at disposition, when the judge gave legal and physical custody back to mom, nothing changed other than custody. Mom still got a treatment plan. She still worked her services. It's just that the kids were living with mom while she did it. But the deprived itself was still going just the same.
Okay.
Does that make sense?
Yes.
So
Can I ask a question?
Yeah.
Just for clarification, because I'm in the CPS side, not the permanency side, so I don't always go that deep into it. Okay, so in your example, it's an emergency, so they're requesting an order for like custody again to take the kids back into legal custody. They're already deprived. But if it was like you're seeing mom backtrack, but it's non-emergency, but you're seeing the backtrack, can they just request a dispositional hearing and redispo the case, have the kids in custody instead of going through doing like the order again?
Exactly. Yes. You can.
Okay.
And when I say custody, there's, like I said, they could do it one of two ways. They could have immediately called and asked that the children be placed in custody via court order, or they could have at the next date at the review hearing the state could have said, hey, it's last minute, but we're asking the children to be removed because of this issue. Now, the state wouldn't have to and this is a really technically complicated question. So Emily, I'll answer your question at the end, because I don't want to confuse anybody else. That's a very technical and, question, but yes, there's multiple options. Okay. But for this point, we're trying to refer to custody kind of like more generally. So in the last example we used, they can, because at the disposition hearing, physical and legal custody were returned to mom. When DHS finds dad in the home and mom using, there has to be another custody order issued, but it doesn't change the deprivation of the case. Okay. Now I'm gonna get really wacky here. We're gonna assume the exact same set of facts all the way down to disposition. Okay. But at disposition, the judge says, mom says, Judge, I really want the children back in my custody. I feel like I've earned it. I've been doing really well, yada, yada, yada. And the state objects. State says, no, Judge, we do not agree to custody being returned to mom, legal custody, but we would agree to trial reunification. Okay. So you guys have heard trial reunification. You've run across it in your cases. You've seen this written all over orders before or in minutes that you've reviewed. That usually stands for TR. Trial reunification is TR. So let's say at this court hearing for disposition, the judge says, I'm going to give you trial reunification. Well, trial reunification means that the state still has legal custody of the child, but mom just has physical custody of the child. Okay. So there's legal custody and there's physical custody. So in the first example, mom got both back. In this example, she's only getting physical custody. She's getting trial reunification. So now, assuming the exact same facts still, the day before the review hearing, DHS goes out and finds dad in the home and mom passed out on what appears to be high. Does DHS have to get a court order for custody?
No.
Exactly. Good job, Marilyn. No. Right? Good job, Beth. Excellent. Yes, I'm seeing some head nods. Good job. So, and the reason why is because there's custody, there's deprivation, but custody can be broken down into legal and physical custody. And so when you hear trial reunification, when I assign you a case and the kids are in trial reunification with the parent, what that means is that the state still has legal custody of the child, but the parent has physical custody of the child. Okay? So it alters occasionally, like in this example, last example, because they're in trial reunification and the state has custody, DHS doesn't have to get another custody order. They can remove the child while they're there. But in the example before that, when the judge gave mom legal and physical custody back, DHS had to get an order to remove the kids. So again, I know it seems technical. You do not have to memorize this. You do not have to know the differences in custody. There's not going to be a quiz. What I hope you pick up on is that the flow of a deprived case is always going to be pretty much the same. The referral, the investigation, the removal if necessary, the show cause hearing, the filing of, if removed, the filing of a petition, the adjudication hearing, the disposition hearing, and then the review and or permanency hearing. As PARB members, you're going to 99% of the time, I'm going to write, wait. As PARB members, 99% of the time, you are not going to be involved in the early stages of the case. As PARB members, you will get involved. Usually, the earliest would be after adjudication, before disposition. So, in other words, I would assign the case to you after adjudication, but prior to the dispositional hearing. Because if I do that, I want your input and I want you to talk to DHS about the treatment plan, visitation, what that's going to look like and what it should look like. The other phases that you will be assigned the case is the review hearing and or the permanency hearing. Okay, so you don't, as PARB members, usually get involved until after adjudication. So you don't, again, all the stuff that we talked about at the beginning about the removal and stuff, again, nothing you need to know, nothing you need to memorize. But it's important to know that any period within these cases, custody can change. Okay, but it does not affect the overall deprived case. And so another good example of this is, let's say the kids are removed, yada, yada, yada. We don't know who dad is when they're removed. Mom doesn't know who dad is. She gives us a couple names, we track them down, we test them, and we find that Tom Smith is the dad. Well, Tom Smith is an accountant that makes $100,000 a year, has other children, he's recently divorced, he, you know, had a wild fling with mom, and he's safe and appropriate. He doesn't have any concerns. He can get them to school. He can get them where they need to be. So we do a paternity test. We establish paternity, and dad says, I want my kid. My kid should be with me. My kid should not be in foster care because I'm safe and appropriate. Can we give custody to dad?
Yes. Yes.
Yep, we can. Does that affect mom's ability or the deprived case? Meaning, can the deprived case continue while mom works services and dad has custody?
Yes.
Yep, absolutely. Let's say that mom completes her treatment plan and does really well, and the kid is 12 years old and says, look, I love my dad, but I don't want to live with I don't want to live with my dad permanently. Like, I want to go back to mom. At the end of this, I want to live with my mom. I want visitation with my dad, but I want to live with my mom. At the end of the case, can the court change custody from dad to mom?
Yes.
Yep, you're starting to get it now. You're starting to get it. And that's what I mean. You don't have to get bogged down into the details, but sometimes to really root out how they're distinct, I have to be detailed in the examples. Let's say that we're in, well, I think that's a good example to end on because it's already 5:32. So does the point that custody and deprivation are mutually exclusive make sense?
Yes.
Yeah. And that custody can change at any point in these proceedings, but it doesn't affect the track of the deprived case necessarily. Now, it can, it doesn't have to. So for instance, in the example I just gave you with dad, the accountant, and dad says, hey, I didn't do anything. I'm safe and appropriate. I want my kids. Can the court give him custody and the case be closed at that point? Do we have to keep working a treatment plan with mom?
No.
Yeah.
No, we don't have to keep working a treatment plan. Yes, it can be closed.
Yeah, that is an example. Like, again, it doesn't, that is a good example. Yes. But yes, we can, like in that one example I gave you with dad, if he's safe and appropriate, and let's say the kids are like, dude, I don't like mom. She's mean to me. I don't want to live with mom anymore. Can we give dad custody and close the case? Yes, we can. But do we have to? No, because take my first example where the kid's 12 and loves mom and doesn't want to live with dad, wants to live with mom at the end. Can dad have custody while mom works a treatment plan and get custody at the end? Mom, yes, yes.
Yes.
So custody and deprivation are not mutually exclusive, but they will always operate within the same framework of a deprived case. Meaning this flow. You're always going to have an adjudication hearing. You're always going to have a disposition hearing. You're always going to have reviews, and you're always going to have permanency hearings. I'm struggling for the right word. That flow of a deprived case does not change. It's just like I tried to demonstrate visually, but I clearly am not very good at this, that again, I look at it like you can have, if we're just looking from adjudication on, but obviously this would apply at the beginning as well. If you've got all these hearings here, custody can change at any point during those hearings. Okay, so even if you have disposition and let's say the court sets up the next hearing is 6 months, not 90 days. And so the court combines the review hearing and the permanency hearing. Between the disposition and the review and permanency hearing, can the kid come in and out of custody multiple times potentially? Yes, they can. They can. So there are a few other caveats to that, but again, they're not ones that I feel like we necessarily need to cover today. They get even a little bit more detailed. But I hope that makes sense to you all. We went over this training as a review again of the types of hearings we have, the flow of a deprived case, knowing that as PARB members, you're not going to see a case generally until after adjudication. And you're going to be reviewing it at one of these 3 hearings right here. Disposition, review, or permanency hearing. So when I send you out the training manual that we went over that first in your initial training, if you want to fast forward, if you will, through the training session or skim it, but really pay attention to the dispo, review, and permanency hearing slides, okay? Because that's really going to talk to you about, hey, this is what the court can do at each of those hearings. This is what the court's going to be looking for at each of those hearings, so that when you are writing your recommendation, you are giving the court information relevant to what they are reviewing at that hearing. Does that make sense?
Yes.
Okay. Any questions?
No, but I've got to go in a minute.
Yeah, no, go Marilyn. Yeah, we're done. We're done with the training. I wanted to keep it to an hour, as close to an hour as possible. And I think right now we started at 4:35, so we're 1 minute over. Again, I don't want to frighten anybody. I don't want you to feel like there's going to be a test. The whole point of today was to review the structure of a deprived case again, knowing that the bulk of your participation is going to be in these 3 areas, so that you can go back and review the training slides on those 3 areas, and understanding that within the structure of a deprived case, custody is a very fluid concept. And, somebody asked me the other day, do foster parents have custody? No, they don't. And I do want to make that clear. And a lot of foster parents think they do. And it's sometimes a lack of education, I think, and then an understanding. The state is always going to be, outside of a parent or a guardian, is always going to be the custodian of a child. Then the state contracts with foster parents to provide care. But foster parents never have custody. Does that make sense? They have a contractual relationship with the state who has custody. Okay, so I was asked that question the other day. I thought it was really very smart. So I just wanted to kind of, delineate that. Are there any questions?
Do we do PARB reviews on out of custody petitions?
Yes. So now I will bring this up because Emily did, and it takes 2 seconds. But just remember how I mentioned that there's legal custody and physical custody. So let's say at adjudication, we're back to my marijuana example. Mom's doing real well, right? And so the judge says, look, I'm going to give you mom, I'm going to do, sorry, wrong example. Remember that in very initial example, not it was the marijuana one, but remember when I said DHS went out and they investigated, but they decided not to remove, but the state went ahead and filed a petition because mom was using marijuana and they wanted to make sure she got services, and there was some oversight by the court. Do you remember that case? That was the first example we started with.
Yeah.
Those are called supervision petitions or out of custody petitions. And the reason why and Emily, I used to do this training when I was in the DA's office with DHS, because at the time we were really trying to get away from calling them those, because it caused a lot of confusion to people about custody, right? Because if we were filing petitions out of custody petitions, that could change at any point, as we've discussed. So that's why I don't refer to those that way anymore. I just refer to it as the petition, but the custody order is separate from the petition. And so in your example, the out of custody, which you mentioned, that would have been the first example where you investigate, but the state never assumes custody, but there's enough concern that we need to file a petition and kind of provide services and provide court oversight. And then, hopefully those should be easy cases. Did that answer your question, Emily, or no?
Yeah, no, I understand them. I mean, they're preferable to regular petitions, quite honestly. Yeah. But my question, I just didn't know if PARB did review on those cases, since the kids are technically still in the home with the parent.
Yes. So as long as the child has been adjudicated, PARB can review those cases. Yes. Okay. Now, do I usually assign them to PARB for review? No, I don't. Unless I see something in there that kind of triggers me a little bit, like I'm seeing a pattern or a concern or, then I will, yes. But I kind of look at how the case is going. But you can, just as long, really for PARB to start looking at a case, the threshold is that the child really needs to be adjudicated. Okay. But there are times when I have assigned a non-adjudicated case to a PARB member, because, for example, I remember assigning one, I think it was to Mandy Damon, who's on your board, mid last year, because by the time we got to adjudication, the kid had been in 8 placements. And that was a big problem. So I assigned it and said, yeah, we got to check on this kiddo. We got to see how things are going. So yes. Okay. Well, guys, I feel like, I hope I didn't confuse you. I hope that answered your questions. But if I did, please don't hesitate to reach out to me. I will answer any questions that you have, and we can talk about it in more detail. I did remind you about, or kind of keep you up to date on the bills that might be passing. I'm going to send you the training manual, and I feel like there was one more thing, but I can't remember it. So if there is, I'll email you. Okay. You guys are free to go. Thank you.
Bye, thank you.
Bye, guys.